SJC-11573, Commonwealth v. John Odgren.
Ms. Garin, good morning.
Good morning. Good morning, Your Honor. I'm Patricia Garin, and I'm here for John Odgren today. Before I begin with the argument, I want to just point out to the court that there are three important facts in this case to which both sides agree. That John Odgren was 16 years old at the time of the crime, that John Odgren had a mental disease or defect at the time of the crime, and that John Odgren used a knife and stabbed a high school classmate fatally, who he didn't know, in the bathroom of his high school. There is no dispute about any of those three facts. The jury learned those instantly in this case.
When you say there's no dispute on mental disease or defect, is there an agreement as to what that entails?
There is an agreement with respect, well, the experts agreed.
The
I should
experts
say,
agreed.
with respect to part of the diagnoses, but not the entirety of the diagnoses. The experts agreed that he had Asperger's, that he had hyperactivity, attention deficit disorder, and possibility of a mood disorder. They did not agree on transient psychosis and several other issues. But they agreed that they all testified he had a mental disease or defect at the time. The only issue for the jury in this case was he criminally responsible? Was John Odgren sane? That is what the trial was about. Now, the judge gave three instructions of permissive inferences that we challenge. They are particularly problematic in a case of a mentally ill juvenile, and those three inferences were: the judge told the jury they could infer malice from his use of a dangerous weapon, they could infer an intent to kill from his actions, and they could infer sanity, because the majority of people in the country, the world, I can't remember her word, the majority of people are sane. And so any particular person, there's a likelihood he is sane. Those three instructions gutted the heart of the defense. They went to the contested elements in this case, and I'll discuss each one briefly. The first
They were all
one,
preserved, Ms. Garin.
pardon me?
They were all preserved?
I would say the malice objection was clearly preserved many times, and the presumption of sanity was clearly preserved. The intent presumption, I think it's not as clearly preserved, because there were objections to various portions of intent, that various objections that the judge did not instruct the jurors on. They should consider mental health when they were considering mental state, intent, malice, the first Kunin factor. We asked for an instruction that the jury consider the mental health evidence at the time they were weighing those elements, and the judge refused to do that. But did we actually say we object to the inference of intent instruction? No.
Okay, thank you.
At the time those instructions were given, they were all correct, right?
They were all part of the model jury instructions, yes. And the judge read them almost word for word from the model jury instructions. First, the inference of malice. The jury was told over objection, you are permitted to infer that a person who intentionally uses a dangerous weapon on another is acting with malice. Of course, there was no doubt Mr. Odgren acted with a dangerous weapon. The judge told them a knife was a dangerous weapon. This instruction, along with the instruction on the inference of malice, both derive from English law. When you look back at the beginning of this law, in the 1820s in this country and in English law, you see that the inferences grew out of the notion that one should be able to infer a fact from a known fact if it's predictable. The standard changed over the years to, is it predictable, is it beyond a reasonable doubt? But But there has to be a relationship between the known fact and the inferred fact. And when you look back at all of this old law, you realize that as early as 1825, this court in Commonwealth versus York said that it is a sane man, not a child, not a mentally ill person, it is a sane man, a voluntary agent who acts upon motives that must be presumed to contemplate and intend the necessary, natural, and probable consequences of his acts. That's from 1825, and that's almost exactly what the inference of intent is today. Of course, it's a permissive inference, but it grew out of what a sane man would do. A sane man would act on motives. Also part of that York case, the court found that that sane man, if he, quote, willfully and voluntarily inflicted a mortal wound, malice could be inferred. That law has lived with us for a long time, but the issue of the relationship between the known fact and the inferred fact has always been a topic of dispute, and now
When you went back and forth with the judge on the instructions, did you highlight this problem? I mean, because we have a chicken and egg, right? The jury has to decide whether he's sane, right? They have to make that decision. They also have to, if he is sane, that's a reasonable inference, right? The problem is they've got to make both determinations. Did you tell the judge he had to qualify or she had to qualify that instruction?
Yes, we had, that was all part of the jury.
And how did you recommend the judge qualify the instruction?
We recommended, as I will today, that when you have a defendant who is a juvenile and a mentally ill juvenile, that there not be any inferences drawn about his mental state.
But if you take your argument, wouldn't it be that, ladies and gentlemen of the jury, if you believe that the defendant didn't appreciate the wrongfulness of his conduct or couldn't conform the conduct to the requirements of the law, then you would not be able to infer any of the, what we call the three prongs of malice from the use of the dangerous weapon.
I believe that would be correct, yes, but I think that would be, I worry that would add to the confusion. I mean, and mental health cases with lack of criminal responsibility defense are tremendously confusing to juries to begin with. I think we would recommend that when you have a mentally ill juvenile, that you should not be instructing jurors to infer the essential elements of the crime.
That may well be right. It may well be that in a juvenile case, or particularly in a juvenile case, when you're dealing with a criminal responsibility or diminished capacity defense, that the infer malice from the use of a dangerous weapon is very confusing and perhaps too confusing. But that's different than if the criminal responsibility instruction was given correctly, whether or not there was prejudice that arose here from the instruction.
Well, that may be, Your Honor, but the criminal responsibility instruction, we think in this case, was not given correctly
Because
either.
of the order in which it was given?
Pardon me?
Because of the order, the manner in which it was given?
That's one part of it, yes. That was particularly problematic, the order of it, yes.
It's going back to the actual instruction, and I have not gone back to read the entirety of her instructions. Did she frame criminal responsibility to be the absence of malice, or did she simply say that it is that the Commonwealth must prove that he was criminally responsible, and that is something that if they fail to prove, you must find him not guilty by reason of insanity?
It was close to that, Your Honor.
Close to.
It was close to what you just said.
Okay, but did she speak of the negation of malice when she spoke of
No,
criminal
she did
responsibility?
not.
So the jury, I know you're concerned about the order, which we changed in the new instructions, but why do you think that we should understand this jury to have believed that a finding of malice, assuming if you're correct that they basically said that he acted with malice, would necessarily affect then their decision as to whether or not he was criminally responsible if that was not framed as the absence of malice?
In this case, it affected it in large part because the order in which the instructions were given and the instruction she gave them with respect to the order. She not only told them that they had to, they could not consider the elements of the crime. I'm sorry, she could not consider, the jury could not consider criminal responsibility until they found a crime beyond a reasonable doubt. That had to perplex the jury terribly. How are they supposed to find a crime beyond a reasonable doubt if they are not allowed to consider criminal responsibility?
For how many years have judges been instructing that way with that
A
order?
lot of years, and I'm glad they're
Oh,
no
no,
longer being instructed.
Okay.
But that instruction, which was objected to, and we talked with the judge at length about why the order of instructions had to be different. That instruction combined with the instruction which she gave telling them that they must convict the juror of the most serious crime that they found beyond a reasonable doubt.
So assuming a judge properly instructs on all those things about most serious crime, criminal responsibility, and proof beyond a reasonable doubt, have we ever found reversible error in the order a judge takes those three propositions?
I don't believe so, no. I know the court's changed that.
Right, we changed it, but
but
have we,
I don't
has it ever
believe-
been held to be
right.
reversible error?
I believe that's right.
So if we've never, sorry, are you done?
I'm done.
Yeah, so if we've never done that, the novel issue you're raising is limited to the juvenile issue, right? I mean, you're asking us to overturn settled law unless we change all of that law. I mean, we've changed the law, but we've never applied it retroactively and reversed, have we?
No, Your Honor, but I'm not asking you to change settled law either. I don't think giving a malice instruction amounts to more than the discretion of the judge to decide whether it's appropriate to give an inference of malice instruction in a particular case or an inference of intent. And in this case, it was not proper. And if you look to other jurisdictions, you will see that they started out with the same kind of law we did, with these same instructions, these same inferences, and they have come to realize that by instructing an inference of malice or an inference of intent, the effect of it is that you are ascribing sanity to the juvenile. You are assuming the not the juvenile, the defendant. You are assuming the sanity of the defendant because those inferences are talking about predicting what your sane, reasonable person will do. That's what an inference is based on. What is the behavior you expect? And in a juvenile in particular, you can't predict this kind of behavior. I mean, when you look at all of the juvenile cases that have come down in the last 10 years, beginning with Roper and going all the way through the cases in this court of Diachenko and Okara, we know you can't predict what a juvenile is going to do. And to say that you can decide that because a juvenile used a knife that he acted with malice, or because a juvenile used a knife, he acted with an intent to kill, that's contrary to everything science has told us about adolescence.
So should we have separate evidentiary rules when we deal with juveniles as a takeoff of Miller and Dachenko?
Evidentiary rules, I'm not sure, but
presumptions-
instructions, instructions, certainly.
Okay, has any court ever held that?
That there must be different instructions, not in this state. I think
Well,
there are other
nationally.
courts that have recommended instructions. I think the amicus that was filed, they've attached some recommended instructions from other jurisdictions.
That deal with juvenile brain development and
Yes.
inferences?
And there are recommended instructions that are used in the Massachusetts courts all the time about those things.
I take it the entire thrust of the defense, though, was to say, none of this work, if he isn't criminally responsible, that ends matters, right? I mean, it's not as if this issue was clouded by this. I mean, the entire defense is, he's not criminally responsible, right? That's the entire, and I take it the jury's got to make that ultimate call, what order they make it in. That's the ultimate decision they have to make. And is there any real confusion about that here?
Well, I think that this jury probably faced confusion. I agree, the ultimate issue is, was he criminally responsible?
And
But
I
if the
take it-
judge in the courtroom tells you, and when a judge tells you, here's an inference for you, it's like a commendation. It's not just a, here's an inference. When the judge says, you can infer malice from his use of a deadly weapon, how can that not be confusing when you're told you can infer an intent to kill and you're trying to decide criminal responsibility? I don't think that's possible for lay people to separate.
If I can turn your attention to the recorded conversations, specifically with the defendant, with the juvenile's parents, what came in with regard to the conversation that he had with his parents when he was in custody?
There were 11 recorded conversations that were submitted. There were 33 hours of conversations that went to the Commonwealth's expert to listen to, and that they referred to them and used them in cross-examining witnesses. And I mentioned some of those cross-examined questions in my brief.
Wasn't the judge pretty careful about which ones she allowed in?
She did sort through them. She was somewhat
There were, what, 10
particular,
or 11 of
yes.
them?
But we think that of the ones she let in, it wasn't like she let in one where the defendant said, oh, I was planning to do this, or he didn't talk about the crime in his conversations.
Well, that's what we were curious about. What did she allow in?
She allowed in, if I have my chart, I can look at it quickly.
Sure.
She allowed in a conversation he had with his parents where he talked about a history class and these violent medieval battles that he loved. He was an Asperger's child. He had a fascination with medieval history. He had a fascination with violence and weapons. He had a fascination with those things as part of his Asperger's. It was part of his preoccupation. And they played a long conversation he had about Viking warriors, attacking people with their axes, and other things about this history class. He had a conversation with his mother and father about laughing about how the police searched the house looking for all of these things that he had on his list of what was going to happen when the world ended.
So isn't all that, I don't mean to jump over the important expectation of privacy argument with this question, although I think I am, and I want to go back to that, but isn't all of that probative of his mental state? I mean, obviously, we're looking at the mental state at the time of the crime, not at the time of the telephone call. But isn't it probative on that issue?
We do not think it was probative, Your Honor, for several reasons. The calls were weeks and months after this ended. Our experts said that it was a transient psychosis that developed from the terrible fear and paranoia that he would sometimes have, that his conversations on any one day were not going to be reflective of what was going on in his head weeks and months earlier, or days earlier. Some of them were several days after, some of them were several months after. Our position always was, and our position with the judge was, that the Commonwealth was putting this stuff in as, frankly, bad character evidence. Our client didn't sound like a nice, sweet, likable kid. He sounded like a kid who was egocentric, who was obsessed with all kinds of things that didn't have anything to do with his present situation, that he laughed about things that other people would not necessarily find funny, that he made jokes about the police.
What does a sweet, likable kid have to do with anything?
Well, the Commonwealth certainly contrasted our client with the victim in this case, how they put their evidence in. I'm saying
So your
that this
client has a constitutional
information,
right to be perceived as a sweet, likable kid?
no, I'm saying that The way they put in this evidence made him appear to be the opposite, that it was bad character evidence, and it was inadmissible. It was inadmissible for plenty of reasons. Everything that was in these conversations had virtually already, if you look at the chart that I put in the addendums, I didn't want to go through every single question separately, but it's pretty long and it's pretty detailed with all the objections and why. And it's in the addendum at page 362 through 376, and it takes each conversation that was admitted and puts in why the judge admitted it, what our objections were, and why there was no probative value to the conversation and why it was prejudicial.
Well, the extent to which you could draw an inference from some of this as to bad character doesn't end the inquiry. The issue here was his mental state at the time of the crime. Again, not at the time of the telephone call, but it, obviously has some probative value in that regard. And to the extent you can interpret some of these conversations as not a likable kid, that's the undue prejudice. But that's not the end of the story. There has to be a balancing. And here, this case is about the defendant's mental state. So I'm not sure about that balance, even if you're correct about that you could infer a bad character from some of these. I think I wrote down 13 minutes out of 138 minutes.
Your
But
Honor,
where's the, long way of saying, where's the undue prejudice when you matched up against the core of the case is going to McCool factors?
the undue prejudice really resounded on the last day of trial. The last day of trial, the Commonwealth's expert was being cross-examined, and the Commonwealth asked if they could play a tape. They'd already played part of the tape. The tape was completely irrelevant. It was having John Odgren laugh about the fact that the police were searching the house looking for things that were on his "this is what happens when the world ends" list. But several people had already testified that he had said that. The evidence had come in 3 other ways. It was absolutely unnecessary, duplicative. The judge let the Commonwealth play it. They played it because it had John Odgren chuckling and laughing loud and hard. And that was how the Commonwealth ended the case, with the tape with him chuckling and laughing and the Commonwealth saying, "The Commonwealth rests." It's a public record. You can look at the headline in the Boston Herald the next day. It was, I don't remember the exact words, but it was something like, "Commonwealth ends with, Odgren laughing about whatever." That was how these tapes were used in this case. They weren't used to prove he did anything. They were used to make the jury not like him, and that's improper. It's just simply improper. None of these tapes were necessary for their content. All of the content of these tapes came in elsewhere in the trial. These tapes were just made so the jury could hear John Odgren talking, and that's what they heard.
Okay, thank you.
Oh, boy, there was so much more to say. I'm sorry, I didn't get to
You have a
10th of
you have a
this case.
100-page brief to read.
All right.
Thank you. Ms. Grant?
Good morning, Your Honors. Marguerite Grant, Special Assistant District Attorney for Middlesex County, representing the Commonwealth. Also present in the courtroom is the trial prosecutor, former Assistant District Attorney Daniel Bennett, and members of James Allenson's family. I'll start with the jail calls where you left off. The trial judge did not abuse her discretion in ruling that the defendant's age and psychological issues did not impact his ability to understand that he was being recorded and to speak. 3 points I want to make about the jail calls. One, this case should be something of a cautionary tale about amicus briefs, because the Odgren 1 case was argued in this court on the same day as matter of a grand jury subpoena. And if you read the dissent in matter of a grand jury subpoena, the dissenting justices, the Chief Justice and the 2 justices who joined with her, were concerned because an amicus brief submitted by this defendant's lawyer made representations about the way that juvenile jail calls were used and how often they were recorded and how often the Commonwealth got them and what juvenile defendants understood about those jail calls. When it decided Odgren won, this court ruled that an evidentiary hearing was necessary. And so the case went back to Judge Haggerty, and she held that evidentiary hearing. But it's important for this court not to make decisions based on representations of facts in an amicus brief without an evidentiary hearing. So that's my first point. My second point is, I can't really wrap my mind around how it's not a valid penological interest for jail telephones not to be used, as they were in this case, for the defendants to say to his friends and peers, I'm being persecuted because I was the one who stayed behind to help, and the real killer is out there. At the same time as he's saying to his parents, I should have used the downstairs bathroom instead, or I didn't know this guy, and the worst they can do to me is manslaughter because I didn't know this guy. Just as in cases like Commonwealth v. Brown, where the juvenile jail calls came in to show that the defendant was concocting a false alibi in conversations with his father and grandmother, similarly, how would it be that a sheriff responding to a jail call subpoena would be supposed to determine where on the slippery slope a jail call may be, whether it's evidence of a crime that's ongoing inside the prison or evidence of instructing?
Is that the problem? What, the
Well-
sheriff, about for the sheriff? That's the
Well,
problem?
that was the majority's problem in the issue before the majority in Commonwealth versus, matter of a grand jury
But the
subpoena.
defendant didn't get to the point of being able to argue the motion to suppress on the tapes, probably because we were too loquacious with our questioning. But putting that aside, their position would still be, when you're dealing with a juvenile, at least this juvenile, that you're dealing with a different expectation of privacy. I think that's what they would have argued.
Which brings me to my third point, and that's that in this case, Judge Haggerty kept her eye on the ball. And the ball was that the relevant question, as she put it, this is at the addendum to the defendant's brief at page 196. The relevant question is whether his restraint resulted from his understanding of the ramifications of speaking on a recorded line. And she listened to 2.5 hours nearly of jail calls and found that the defendant only listened to only spoke about the crime in a very small fraction of them. It's important when the court is thinking about the jail calls that the court focus on the jail calls that actually came in.
And how many were they?
Excuse me?
How many were they?
10 in the Commonwealth's case in chief and 1 in its rebuttal case.
But the
And-
experts got to listen to all of them. Your expert got to listen to all of them.
Yes.
And that came out?
Well, didn't, along those lines, with Justice Lenk's question,
Wait, actually, let's first answer Justice Lane's question.
no, I
and
was
then-
going to
then
ask
we'll get
about
to-
that one, but go ahead.
The prosecutor was very careful about when he was going to have our expert listen to the jail calls. Because this evidentiary hearing was happening in March of 2010, with the firm trial date in April of 2010, he waited until the judge was done with her findings on the motion to suppress, and he specifically asked in the courtroom to make it clear which calls he was going to give to Dr. Fife. And Dr. Fife listened to them on the eve of trial, and I can't represent now exactly which calls it was, but it is in the record on the motion to suppress.
My question is, were they the same calls that came in at trial? Or were
Those
they other calls? that
plus
she
other
was allowed-
calls, yes, there were other
But
calls
other calls she was allowed to listen to?
other than what came in at trial, correct.
Yes.
But the jury heard the calls that came in at trial.
Only?
There was one reference that I can remember on cross-examination of the Commonwealth's expert, Dr. Fife, when defense counsel asked her words to the effect of, was there anything the defendant said in the jail calls that was, I can't remember the word the defense counsel used. It was either non-responsive or unusual, or it was a word like that. And she demurred a couple times and said, well, you'll have to refresh me. He said a lot of things. And defense counsel said, well, tell me, what can you think of? And she said, I remember an occasion when he talked about what it was, the sound that a video game character made when its throat was slit. She made a passing reference to that. Defense counsel objected and moved to strike, and the judge found that he'd opened the door. And that's in the volume 15 in the cross-examination of Dr. Fife. But it's important when you're looking at the jail calls to focus on what came in, and any references to other facts would not have been clear to the jury at all. The judge also weighed prejudice versus probative value, and she was...
But did the judge think that the issue had been decided in re grand jury?
No. She was very thoughtful in her analysis of this. She went through matter of grand jury subpoena and Commonwealth v. Hart and noted that this court in Odgren 1 had remanded the case for an evidentiary hearing, and she quite clearly understood that the court was leaving her discretion. But she ruled...
Well, it was not, I mean, I think I was on the court, it was new then, but my memory is it was remanded recognizing that she had to address the constitutional issue with regard to as to a juvenile, whether or not those jail calls could be subpoenaed.
Correct. And she understood that. She held an evidentiary hearing. She listened to the jail calls. This was an evidentiary hearing where both of the defense experts who testified had never met the defendant, and there was no information that they had listened to the jail calls. The defendant didn't submit an affidavit or testify at the evidentiary hearing, so the basis of this assumption that he had some residual expectation of privacy, that the jail calls wouldn't be turned over to the prosecution, it seems to have come, frankly, from the factual representations made in the amicus brief that the matter of grand jury subpoena dissenters relied on. It
Right.
becomes...
But, I mean, put aside the issue of his subjective expectation. Was there any part of the evidentiary hearing which discussed the penological need for the recordings and specifically focused on the juvenile's conversations with his parents, which is what the amicus is focused on?
There was testimony both from a DYS employee and from a Plymouth PCCF employee talking about the penological need for security, for having all jail calls recorded by PCCF, and the fact that DYS monitors all juveniles' calls in order to encourage juveniles to maintain relationships with their parents and make sure that the juveniles are doing okay. This juvenile, in addition, had other ways of communicating with his parents. He could write to his parents. There was a special exception made for him to speak privately with his parents that's referenced in the record. And also all juveniles in DYS custody are allowed one free call a week of at least 10 minutes long that's monitored by DYS but is not recorded or monitored by PCCF. So he had other mechanisms for communicating with his parents. He, of course, had unfettered ability to communicate with his attorneys. And so the record doesn't bear out what the matter of grand jury subpoena dissenters thought it did.
What is the statute changed with regard to the legislature created 2016 or 17 or 18, I forget, but well after this trial, a statutory privilege with regard to parents testifying against their children. Have we ever considered, in light of that privilege, the admissibility of these types of telephone calls against a child?
There's a footnote in my brief about that. It's a disqualification preventing a parent from testifying about communications about legal advice with the child. And in fact, one of the jail calls that Judge Haggerty excluded as more prejudicial than probative had to do with the parents discussing the execution of the search warrant and some issues to do with the pendency of the case. That last jail call that came in rebuttal, Judge Haggerty let it in her discretion because on cross-examination of Dr. Fife, defense counsel very strongly implied that the defendant's list of items he wanted to have with him when the world ended, that showed that he really was actively psychotic and really thought that the world was going to end. And so to rebut that inference on cross of Dr. Fife, the judge permitted the Commonwealth to introduce the jail call in which he said it was a joke, that list. And he laughed at it as a joke, which showed he did not think the world was really ending. He was not psychotic. And that was cumulative of another jail call that had previously been let in to his brother, also saying that list was a joke. I'll move on to the jury instruction issues. This judge instructed directly from the model jury instructions on homicide promulgated by this court in 1999, as they were then extant at the time of this trial 9 years ago this week when it began. The issue about the sequence of instructions, even now, that's within a judge's discretion. I'd also point out that at the very beginning of trial, at the Commonwealth's request, the judge gave an instruction on the definition of criminal responsibility. Again, during her charge, her final charge, before she instructed on the elements of murder, she cautioned them that in a few minutes she'd be instructing on criminal responsibility. She can't say the same thing, two things simultaneously. They have to be put in some order. And she has discretion to put them in this order, even if she were trying the case today, particularly where she gave him a roadmap at the beginning of the trial and at the beginning of her charge that she would be discussing criminal responsibility.
What about the instructions that we've said don't do it that way anymore?
I don't read the instructions to say don't do it anyway. It's page 1 of the 2018 model jury instructions. It says in the judge's discretion.
No, I don't mean as to that. I mean, not as to the order. I meant as to the other instructions.
Oh, the only one that you said don't do it anymore is the inference of sanity.
Okay. As to that one, the defendant made an argument about that, right?
Correct.
What do we do with that?
Well, at the time of this trial, it was good
I'm
law.
just saying, but afterwards we say it's not good.
Correct,
And the defendant has made an objection saying it's not good.
correct.
What do we do about that?
So he's
Nothing?
preserved the issue under cases like Lawson, even though the law changed 6.5 years after this trial. But here the evidence was overwhelming. This was not merely
The evidence of sanity?
yes. This defendant, months before trial, told his forensic science class he knew how to commit the perfect murder. And he described getting a victim alone in an enclosed space, wearing clothes that covered himself, and stabbing the victim with a long, flat knife. The Madness Avenger video shows cartoon characters being stabbed and immediately dropping to the ground. The forensic science homework that the defendant did, where he was supposed to draw a crime scene diagram, he went further than that and described the victim was stabbed and fell backwards, immediately died.
And this all shows sanity, you're saying?
Yes. And it shows not just use of a dangerous weapon, but planning to use the dangerous weapon, extreme atrocity or cruelty. He, the day before the murder, he asked if he could bring a sword to school, and his history teacher said, no, you need to get your permission of your housemaster. The morning of the murder, he watched Madness Avenger, and then he chose that knife from a set in his kitchen, that 10.5-inch butcher knife, and he brought it with him to school, and he walked through the hallways. He went into one bathroom where inferably no one else was in that bathroom. He then went to the bathroom where the victim was. He followed the victim into that bathroom up to the urinals and attacked the victim from behind, stabbing him 5 times, including in the lung, liver, and heart. That's not just use of a dangerous weapon. That shows planning and premeditation. And that brings
The question
me,
is, does that show sanity?
that was a question for the jury on the judge's instructions.
If
Given the-
if it shows sanity, then the evidence could be seen to be overwhelming, but it doesn't, if that doesn't show sanity, how does it help?
Well, that was for the jury to decide whether it showed sanity.
Yes,
The
of
defense
course.
was arguing from some of those same facts that no one would do this.
But if the instruction was incorrect,
The instruction wasn't, well, the inference of sanity, as in Wawaru, did not make a difference in this case. The judge made clear that the instruction on inference of sanity, that it was a permissive inference. And
how did the judge make that clear? Could you help me with that?
but by giving the instruction as directed at Model Jury Instructions, page 50, 1999, referring to it as an inference and saying that you may, but you need not draw that inference.
Not.
She also instructed, sorry, excuse me?
I did read that part. It's on volume 15, page 207. I believe she said, if you feel it appropriate, you may take into account that the great majority of people are sane and that there is a resulting likelihood that any particular person is sane. So was there a different instruction than that, or is that?
That's the instruction. And she also instructed from the MCLE instructions, section 1.9, that you can infer that somebody intends the natural and probable consequences of their acts. And this court in Brown held that that language is permissive.
I think the argument for the defendant, though, is, I mean, I don't know that it was this specific, but all the information that the jury heard that you just went over certainly suggests that he understood the wrongfulness of his conduct. But on the issue of conforming conduct to the requirements of the law, I think what the defendant is saying is the judge is living with this jury and has a certain role in the courtroom with the jury, and then the judge, as part of her instructions here, is telling the jury most people are sane. I think that's their argument. And that really has an impact. I think that's what they're saying.
As far as controlling conduct, the jury also heard evidence that the defendant got up that morning and he took his 2 van rides to school and he joked with the van rider and answered trivia questions. He walked down the hallways of the school past Brendan Piper, who was his person he threatened previously, and said just the day before, "Don't worry, I'm not going to kill you." He dropped his things off at the Go program classroom, went past the band room where students were raising money for Hurricane Katrina victims. Then he went upstairs to the he went to the first bathroom near the band room, then he went to the second bathroom. So it's not just his use of the dangerous weapon. They could see from the evidence how much he controlled his conduct and how he talked about.
Getting back to the presumption of sanity, since we've said it's no longer viable or it's no longer good law, what have our cases done after that as far as reversible error goes?
They have said in situations like this, where the instruction was correct at the time the judge gave it, they have said it was error for the judge to give it, but in the circumstances, it was not reversible error.
Well, haven't they focused? They focused on 2 things, right? Wayru is a good example. Did the trial judge, quote, strongly and specifically instruct that the burden is on the Commonwealth to prove criminal responsibility beyond a reasonable doubt? That's the first part of the inquiry. And the second part of the inquiry is how much evidence there is of criminal responsibility, right? What you've been debating with Justice Lenk, right?
Yes.
Those are the 2 parts of the inquiry.
Yes.
Did we get the specific, I take it we have the specific instruction that the burden is on the Commonwealth to prove criminal responsibility beyond a reasonable doubt here?
Repeatedly.
Okay, so we have that, but then the question is this case different from Wayru and the other subsequent cases where, in terms of the amount of evidence we have on criminal responsibility or lack of criminal responsibility, right?
Right, and my answer is it's overwhelming because there's all of this discussion for months in advance about committing the perfect murder and bringing weapons to school, and how exactly he's going to do it. And the almost case is overwhelming. On the 33E argument, this certainly doesn't warrant an involuntary manslaughter. That instruction wasn't given, and there's no basis for it in the facts. I would call the court's attention to Commonwealth v. Pagan and the trial judge's analysis in this case on the 25B2 motion, declining the defendant's request to reduce the verdict to second-degree murder. There's certainly no grounds for manslaughter in this case. The Commonwealth would request that this court would affirm the convictions on 2 theories of first-degree murder, and also that the court allow the Commonwealth's motion to transmit the exhibits and pleadings to this court for its review of the whole case on the facts and the law.
Why are you so fixed on getting in, allowing us for 33E review, the motions by defense counsel for expert funds? I know that I was single justice. You pressed it then. I didn't get it then. I don't get it now. Why should we be reviewing ex parte communications that the defense appropriately has, asking the court to give them money for experts as part of our 33E review?
Well, I spend a lot of my professional life in the courtroom where Nicola Sacco and Bartolomeo Vanzetti were tried. I take very seriously this court's obligations under 33E. I'm very aware that there could be motions in future saying that this defendant's trial lawyer should have made different decisions on what experts he used at trial, if there were tests done that the Commonwealth's funds paid for in those ex parte motions, that this case, this hearing today may not be the end of this case. But this court has an obligation under 33E. I have that obligation too, to examine the whole case, the whole record, and see if there's anything in there that this court would have done differently than defense counsel or than the Commonwealth, and to think about that in its 33E review. That's what concerns me, aside from the fact that under Diachenko 2, the defendant is going to have the right to have yet more psychological evaluations done in connection with a parole hearing, and it would at the very least inform the parole board to know about those ex parte motions for funds and which experts they were for. But that's perhaps for another day. My main concern is the whole case issue, and I really do take that very seriously.
All right, thank you.